Thank you, Mark.
Well, I've got a bit different perspective on things than Kelley does. I'm sort of the trade association puke here. I do tax policy for a living. I've been doing it for almost 20 years, and I represent software companies. I came to this world in 1993, and at that time software was being distributed on these little plastic discs that you stuck in your computer. And the trade association I was working for back then started monitoring the migration of software distribution on these discs, on these plastic diskettes, to the CD-ROMs. And a little bit later on later in the 1990s, we started seeing software being downloaded. And now we have a situation where you don't even need to download the software anymore. We have cloud computing. And to pick up on all the analogies that have been used about how there's competition between sort of the tax law and technology, I think it's like a horse race. Technology is a horse named lettuce, and it's always going to be leading by a head. The tax law is a horse named named tomato. It'll always be catching up. And what the states are doing on cloud computing is a horse named rubber band, and it's stretching. So to get back to what I've been doing, in the middle 1990s, in the late 1990s, there was a project put on by the National Tax Association called the NTA Communications and Electronic Commerce Tax Project. And it started the initial work on trying to get the states together to simplify and come up with a plan to how to streamline their sales tax rules. At about the same time, Congress was considering the Internet Tax Freedom Act of 1998. And a lot of people, one of the things I learned early on when I came to the tax policy world was whenever you look at a piece of legislation, you look at the title, you can almost always bet that the legislation does the opposite of what the title says. The Internet Tax Freedom Act did not make the Internet tax-free, as we all know. The only thing it did for tax freedom was to prevent the states from imposing their sales tax on the fee that at the time you paid to AOL for dial-up service. I think DSL was just coming into vogue then. But one of the things that ITFA did was to say that you couldn't discriminate against electronic commerce. There's two prongs: the taxation of the internet access, and sort of what I'll call the application of the Quill physical presence standard to sales taking place over the internet. Now, also at the same time that ITFA was coming down, the OECD had a ministerial conference in Ottawa, Canada, and it was on electronic commerce. And one of the things that the OECD ministerial, that came out of that OECD ministerial was sort of the principle that no new rules were basically needed for the application of the tax laws to electronic commerce. Now, ITFA got passed in 1998, and another thing that ITFA did was it established the Advisory Commission on Electronic Commerce, chaired by Governor Gilmore from Virginia. And the Gilmore Commission was unable to reach agreement, but they basically laid the groundwork for what later became the Streamlined Sales Tax Project, which is still ongoing today. And ongoing today, we have the Marketplace Fairness Act, the legislation pending in Congress that one of these days I think we're going to see sales tax being collected on internet sales. But one of the features of the Marketplace Fairness Act is the incorporation of the Streamlined Sales and Use Tax Agreement. So, we've got all this work that's been going on for how many years? At least 15 years on tax policy. And sort of interspersed in that, you have what Kelley referred to as the -18 regs, 26 CFR 1.861-18. And that regulation was promulgated back in the mid-1990s, and I recall, because I was writing comment letters in favor of the promulgation of those regulations. There was Interestingly enough, there was a dispute in the software industry over how that ought to go. One company, one large company, largest software company at the time, was against it. The rest of the industry was in favor of it. Yeah. Overlaying that, we have the Digital Goods and Services Tax Fairness Act. Last year, 2 years ago, the bill was filed by Senators Wyden and Thune, and that bill had would have had some very profound impacts on how states were able to tax what we've been calling cloud computing. And basically what that would have said was that any provision of a digital good, a digital good was defined as movies, music, books, software, anything you can download over the internet, is going to be characterized as the provision of a digital service unless the customer received a complete copy of the digital good. And to me, that provision would have given a very clear guideline between what is a digital good and what is a digital service. And I think Kelley probably agrees with me that generally speaking, cloud computing would fall in the digital service side of the house because you don't get a copy of the digital good. Interestingly enough, another provision of the bill would have said that any state guidance that might have been existing at the time that the bill passed gets nullified if it said that that something is characterized as a sale of TPP, even though you don't get a copy of the digital good. Now, fast forward to Wednesday, and Senator Thune filed an amendment to the Marketplace Fairness Act with a revised version of the Digital Goods and Services Tax Fairness Act. And that amendment did not have the provisions I just described, nullification of state guidance, the clear distinction between a digital good and a digital service. And the reason it was taken out was because the state governments didn't like it. Naturally, part of my work is to try to get it put back in, but we've got a House of Representatives where we'll be working on that. There's another piece of federal law out there that I think has been overlooked that's relevant, and that's under Section 199, the deduction for domestic manufacturing activities. And at the time Section 199 was passed, I believe in 2003, there was a provision in the section that said that the 199 deduction is available for revenues from the sale of software. Immediately after the bill got passed and Section 199 became law, some interim guidance came out from the Treasury Department that said that 199 deduction was not available for revenues from what they called online software, which I think we all understand, at least at the time, was cloud computing. And of course, the people I represent went nuts. And they sent me in, and we came up with a proposal that said that the 199 deduction will be available for revenues from online software if the company providing the online software also sells copies of the software, either by disk or by download, or somebody else in the marketplace sells substantially the same or similar software on disk or by download. So, at least the industry was saved. The only people that sort of got left out in the cold was somebody that came up with some innovative software that only got provided online and there's nobody else sold it on disk. But I guess the way they can sort of plan around that by finding one customer that they can give a disk to. We've had a lot of conversation about sort of the various flavors of cloud computing. When I first came to this business in the early 1990s, I quickly learned that there were sort of what I call three types of software. There's operating system software, there's application software, and what we call software tools. Software tools were used by software developers to develop application software. And the way I understand cloud computing to work is that there are direct analogs to the provision of the operating system, software tools, and application functionality to, we're calling it IaaS, is that what you said? IaaS? I'm going to work on that one. PaaS and SaaS, I believe that the primary software functionality that a customer for IaaS would get would be the operating system, functional equivalent. The PaaS, the platform as a service, is something used by software developers to develop software applications. That's probably a cloud delivery of software tools software. And of course, the software as a service is the provision of software applications in the cloud. You know, one of the problems we're running into is, as Kelley mentioned, is that most state sales tax laws are limited to sales of tangible personal property and certain enumerated services. And what we're seeing is the states stretching their, you know, under streamlined, their definition of tangible personal property specifically includes computer software. They have a provision that allows a state to exempt software if it's delivered electronically. There's also language in the streamlined sales and use tax agreement that says that downloads of things like movies, music, and books and things other than software are not tangible personal property. And at the time those rules were being developed, we had to come up with another way to describe how they were provided, because we already had delivered electronically for software, which required, at least in my view, a physical transfer of a copy of the software to the customer. At the time we were developing what we call in SST parlance the specified digital products language, which is the movies, music, and books, we recognized that there were these subscription services where you never got a copy of the product. It was up in the cloud somewhere. I think Rhapsody was a music version. We were aware of some video products that were available where you never got a copy. So it came up with another word called transferred electronically. And that encompassed sort of a broader array of products where the product stayed in the cloud. Now, what we thought at the time that there was a clear distinction between delivered electronically and transferred electronically. Delivered electronically required a physical delivery. It only applied to software. Transferred electronically was broader. It included cloud delivery, but it didn't apply to software. And the states that adopted, the 24 states that adopted these rules, sort of forgot about all the telephone conference calls that we had back in the mid-2000s about this. And they're saying now that, they're construing transferred electronically, number one, is applying to software and not requiring a physical delivery. So that's causing considerable controversy at the streamlined Sales and Use Tax Governing Board. I think that's, those states that shoehorn cloud computing into their imposition on sales of tangible personal property need to be very careful about what they're doing. They, sometimes, it's the old adage, be careful of what you ask for. Because even though, characterizing, an imposition on sales of TPP as applying to cloud computing gets you sales tax on the sale of the service to the customer, it also may entitle the cloud service provider to sale for resale exemptions on all the stuff that it buys to provide the service. Because if they're selling tangible personal property, then it's not a service, and they should be eligible for a sale for resale exemption. And one other sort of aspect to this, when the Streamlined Sales and Use Tax Agreement was first enacted, there was a section that specifically allowed for a customer to give the seller an exemption certificate where software was going to be used in more than one jurisdiction. It allowed the purchaser to accrue the use tax and pay the use tax to the various jurisdictions where the software was going to be used, rather than have the software collected, or excuse me, not the software, the tax collected from a single state, where the purchaser would then have to get a refund of part of the purchase price and then pay use tax to all the other states. That was very controversial. It got repealed but there are vestiges of it in the streamline that remain. There are some rules under Section 309 of the agreement that specifically say that if a purchaser and a seller agree, they can allocate the sale and purchase price to the jurisdictions where the software is going to be used. And I think that's about all I have right now.
Thank you, Mark.